Well, howdy, everyone. I'm David Glazer, and I'm here with Deborah Schneider.
Hello.
Actually, Deborah Schneider is here. I am the parsley on the side of the plate today because she's going to be doing most of the stuff. I will mostly do announcements and then wrap us up at the end and make some interjections in the middle. So on the announcement front, longtime listeners know if the sound goes south, you can always dial in to the number that Robert puts in. If you're wondering where the slides are, you can get a copy of them in the email. The same one you used to click on the link right now has a hard copy of the slides. If you're wondering about CLE credit and HCCA credit on this, you will get an email in a couple of days that will also have a link. All of our webinars are recorded. And so that link, you can use that link to both view this one again, or if you want to forward it on to someone, or if you want to see any of our past webinars. We've been doing this for almost 13 years, and about 8 years of those are available online. And so you can either go to fredlaw.com or just look at the webinar, or just look at the email when you get it. If you've got like 6 people sitting in a room and you want to get CLE credit for all of them, if you send an email afterwards to Sarah Cedar, that's SCEDER @fredlaw.com, she can, if you send a list of the people who were there, she'll take care of that. Only other announcements, next month's webinar is usually our biggest. It's the frequently asked questions. You can send us the questions. It'll be a week later because of Yom Kippur. It'll be on October 16th, same time as this one, so 1 o'clock Eastern, which, what is that, 10 o'clock Pacific? And so send us your questions. You can send them to Katie Ilton or to me. Just put webinar question in your subject line. The whole, or much of the Health Law group will be here answering your questions then. The following week, Katie Ilton and Ryan Johnson, not the following week, the following month on November 20th, Katie Ilton and Ryan Johnson will be doing telemedicine. And then in December, we'll be doing our annual regulatory update on both the inpatient and outpatient rules. All right, the only other thing I promised a trivia question that wasn't 80s. So this is for Chachka. There are 2 states that border more states than any other state. And this question appeared in last month's confirmation email. And Deborah and I are working on very little sleep. There were loud thunderstorms here last night. So hopefully we'll be more articulate than I have been thus far. But what 2 states border more states than any other state? Hint, they border each other. So the first person to send that answer to Robert will get a prize. The answer will appear in the confirmation email. Now, I am joined by Deborah Schneider. Deborah is an immigration lawyer. If you've got professionals who need to, get permission to work in this country coming from abroad or stay in the country, Deborah and her colleagues help on that and do a great job. So you can always call Deborah, Lon, Bob Aronson, Laura Danielson for questions like that. But today, Deborah is going to help us figure out what you do if ICE shows up at your clinic and hospital, and also kind of talk about a variety of other sort of related issues you need to know about dealing with immigration, both for your employees and for patients. So, immigration right now is a politically loaded topic, and I am going to try to steer clear of the politics, despite the fact that, I feel lucky to be here because I have relatives who fled from other places to be here. But I think however you feel about immigration, if you are an immigrant right now, you sort of feel like you are being watched. So I took this red-tailed hawk was in my backyard last Wednesday, and I took a kabillion pictures, and this is one of them. Deborah, what do you think? People are feeling watched if you're an immigrant. What do people need to know? Take it away.
Thank you, David. I think this picture is actually very apropos because it actually could feel like ICE is not only looking over but feels a bit like a predator-prey situation. Immigrant communities have been very frightened over the last few years with changes to the administration, as well as changes to kind of the political rhetoric about how we perceive immigrants regarding building a wall, regarding what we've seen in changes in how they treat asylum seekers, individuals coming in at the border, and everyday professionals who are working here with proper legal work authorization. We've seen a tremendous pushback by the agency. And so the Hawks are indeed well fed right now and well funded. And so I'm here today to talk a bit about what happens when, I don't want to just keep calling them hawks, but when immigration agents may come to your hospital or clinic, and what this may mean not only for your employees and patients, but even just visitors to your facility. So first, a little bit about who is Immigration Customs Enforcement, or the acronym ICE that they really enjoy using. And it's, as today is 9/11, that is really the impetus of how ICE was created. They came out after Congress evaluated what had happened with the former Immigration and Nationalization Service, and created the Department of Homeland Security. And within that, they created 3 agencies. The first is the United States Citizenship and Immigration Services, which essentially is the agency that processes immigration benefits. They also created the Customs and Border Protection, which essentially are responsible for people and products entering the United States. Finally, they created ICE, which is responsible for the apprehension and removal of foreign nationals from the U.S. So they are truly charged with enforcing U.S. law and helping deport individuals. There's nearly 20,000 ICE agents, and they have an annual budget of over $6 billion. So yes, they're very well funded and supported right now. Within ICE, I think it's important to talk a little bit about the agency themselves. They have 3 main units within ICE. The first is called Homeland Security Investigations, and they go by the acronym HSI. And this is the agency that oversees criminal investigations, as well as investigations relating to enforcement actions such as I-9 audits. So if you have visits to your facility and you've been served an I-9 subpoena, while it's ICE, it's going to be HSI officials. These individuals rarely wear ICE jackets. They're going to be regular clothes. However, they always come in 2, and they do carry weapons, which is always fun when they come to meet with me to serve a subpoena on a client and also reference that. A little interesting. The other agency, which are the individuals who wear the blue jackets that say ICE or police in bright yellow letters, are called the Enforcement and Removal Operations that go by the acronym ERO. They're the agents on the streets, and their job is to effectuate warrants to individuals and to arrest and detain. And finally, the third office is the Office of Principal Legal Advisors, or OPLA. If any of your employees or individuals are ever put in deportation proceedings, called removal proceedings, they are essentially the prosecutors. They're the individuals who are litigating on behalf of the government to charge individuals with removability. They also provide advice in federal litigation on behalf of the agency. So why would they be visiting your clinic or hospital? Well, generally, they're going to be there likely to arrest someone. If they're going to a hospital or clinic, which is a secure, supposedly sensitive location, they're normally going to be there because there's somebody they want who they've found at your clinic or hospital, unless they're serving a subpoena, for example, for documents or records.
So, Deborah, you mentioned a sensitive location, but maybe you can elaborate a little on what a sensitive location is.
So in 2011, ICE issued a policy memo. This agency, I should say all immigration agencies love policy memos. And this one talks about sensitive locations, which provides guidance to their officers on what certain locations throughout the country are they not supposed to go visit. This includes hospitals, and in fact includes healthcare facilities, including hospitals, clinics, and other emergency services. It also includes religious institutions such as churches or mosques, schools. As you can see, what they've determined to be sensitive locations are places where people should generally feel safe, and places where people need to go to, for example, they want to leave their children or they want to have a free place to worship. There are exceptions to this sensitive location policy, however. While they're not supposed to go there, they can if exigent circumstances exist, if other law enforcement actions have led them to this sensitive location, or if they've been given prior approval by a higher level supervisor. So while this policy is intended to guide them to avoid these locations, an important factor, as we'll talk about more, is that there's really no repercussions for them to do so.
And so I know you use the word policy. Right? So are they prohibited from going to those locations, or it's more like it's guidance? It's
guidance. There has been talk for legislation to actually make it regulatory, but that hasn't passed. And so I'll talk a little bit later about what actions can be taken by your organization if they do come, and what you should do. So probably one of your questions are, well, what are current enforcement actions? What is going on? I think the biggest item we've heard is really when we heard announcements that there's going to be large immigration raids going on throughout the country. And this is where I think you started seeing questions in the news, people started taking actions. What does this mean? It didn't truly happen, right? We didn't hear this mass arrest, but in reality, they are going on a small scale all the time. I'm on the ICE listserv, and I get to hear their promotions about, fantastic, we just arrested 10 people in Connecticut, and 25 were arrested in San Diego. And so they're constantly doing small-scale enforcement actions. It has not been primarily at these sensitive locations. I think the biggest arena right now is the controversy of them showing up at courthouses. But it is something that when they do see this happen, and there's been reported activities when people, especially coming in at the border, have required emergency medical care, and ICE has followed them, and in some circumstances then arrested and put people to deport them immediately after care is provided. So that creates a whole level of fear that hadn't occurred before. So as I talked about, the rules that apply to ICE are basically trying to figure out why they're there. So they shouldn't be in your hospital or medical facility. So if they're there, they're likely there either because they believe that there's someone there for national security, or they believe there's some act of terrorism, or there's an immediate risk of destruction of evidence. So basically something tied to an investigation or someone they're interested already. Otherwise, they could be there for, again, the HSI unit. It would be very common for them to be there for serving a subpoena on your organization. As we discussed before, there's little repercussion if they violate policy. Certain things that you can do is they have two lines that employers can call, and we'd be happy to send a link to these if you want to have them. Essentially, you can contact ICE by reporting that they showed up at your facility or your hospital and you didn't want them there. And there's also the ICE Office of Diversity and Civil Rights. Those are how you file a complaint, which doesn't give you a lot of free will because those are actually the exact same agencies that you're reporting to. So most likely, if we see ICE taking aggressive action, it's probably going to be something that you're going to turn to the press to, because it's going to be well known, because people are going to talk about it. So let's talk about what agents they can't do. Well, they can't gain access to your medical records without a subpoena or a warrant. They can't interfere with medical treatment, and they are subject to the Fourth Amendment of unreasonable search and seizures just like any other government agent. But what can they do? Well, they can serve you with a warrant. They can do investigations of your business. They can conduct what we call as FDNS site visits. So if you have filed paperwork to sponsor foreign nationals, they can send agents into your facility to interview the individual who's been sponsored and interview the manager and confirm that the information that's been presented to the agency is in fact accurate. We've also seen them for the first time start with STEM OPT students. So these are foreign students who may be working for you under employment authorization. They just recently started doing site visits to confirm individuals working on these documents are really at the same employer that they noted to their DSO at school.
So the Fourth Amendment, I think, often is confusing to folks. So let's operationalize this for a moment. So, the waiting room, public area. I assume an ICE agent can hang out in the public area like anyone else, right? You can't really throw them out of your waiting room.
That's true. Mm-hmm.
They want to come back into the patient area where you would not just let anyone go. Can they do that?
No.
So you're supposed to just say no to them?
In a very polite, nice way. So what we recommend, and I do have slides on this later, is to designate appropriate areas within your facility. Make it very clear what are public and what areas normally you see signs that say unauthorized access only, right? You see this closed, many hospitals have locked doors or say that. Once that notification is there, it's very clear they can't enter that. If they don't see that, they're going to push the envelope.
So I'm realizing we're going to come to this a little more in a bit, but basically, is ICE different from a regular police officer?
No. not unless they have a warrant. They also can act on probable cause, just like a police officer. If they're pursuing for a national that they have a warrant to arrest and they have probable cause to believe they're there, they in fact can continue on in those same elements.
And some of you remember from a past webinar we talked about, I think it's Nurse Rubel, she was the University of Utah nurse who stood up to the police when they were trying to take a search warrant, and who is a hero of sorts to me. The same sort of approach is true here. You can and really should. I think there's actually you have a duty to your patients when any government agency is attempting to come in. If they lack a warrant or other probable cause, I think you have a duty to protect your patients from overreaching by the government. Basically, it's part of your job and ours.
Agreed. And so what actions by ICE are covered under this sensitive location policy? Well, it includes enforcement actions, which would be if they're there to arrest someone, interview someone, search someone, and if they're doing surveillance for immigration enforcement only. And so what has happened is ICE will often say, well, I wasn't here for enforcement, all right? I just was following a lead, and it just turned into an arrest or search and investigation. So because this is only policy and guidance, it's up to them to define their terms of enforcement, and they will push the envelope as much as they can. Yeah, and so where can they go? Just as David said, your public spaces. Can they question visitors in the lobby? Yeah, they can. What about patients who are awaiting admission? If it's an open lobby, they can start interviewing individuals who are there, family members of patients. And so one of the risk factors are if the person that they want to arrest is actually getting treatment, but the family members are there, what can happen is that ICE will interview the individuals in the waiting room, and if they don't have documentation of their status, they very likely could be arrested or then serve charging documents because they're not able to access the person they want, but they're going to go ahead and take their family. That's a risk, and so one of the things are, what can you do? You can ask them to leave, right? If you see individuals in your lobby being harassed or interrogated, and if they don't have a warrant to be there, you may ask them to leave at this time to try to protect the individuals who are using your facilities. What else can they access? Well, items in plain view, right? This also goes to the Fourth Amendment. If you leave files out in the open, can they look at it? Yes. Obviously, in a medical facility, we would assume this would never happen. You're going to have HIPAA and patient confidentiality. You're not going to leave things in plain view, but always something to be cognizant of. And then they can listen to conversations in public areas. If they hear individuals talking about something that leads them to have probable cause, that could also happen. I think other questions that come up are, are ICE going to be coming in with their jackets and guns a-blazing? Likely no, unless they're executing a warrant in those exigent circumstances where it's a hot lead, right, and they're in there. But what we also have heard is federal agents are waiting outside of hospitals or clinics. And if foreign nationals, especially those who may not have legal status here, see those jackets and see ICE, they're petrified to go into your facility, and they won't access care. That's just a given. That's just not going to happen. And that's what we see occur in certain communities because ICE has a large presence there.
So one of our eagle-eared listeners, and I guess that should be eagle-eyed, but it's a webinar, caught me in a mistake. So I said Nurse Verbal was, and I'm messing up her name, which is bad to do with the hero, was standing up to someone with a warrant, and I'm totally wrong. It was without a warrant. So I had that one backwards, but it was the police coming in and demanding a blood draw without a warrant. Although actually, the ability to use a warrant for a blood draw is an open question right now, and kind of how and sort of how some of that goes. But that's another story. And also, the eagle-eared listener had a question for you, Deborah, which is, if you've got a visitor policy at your hospital, is an ICE agent, assuming they don't have a warrant, different from any other visitor?
They would like to think so, and we'll try to convince you of that, but you still have the authority to discern who can and can't be in your lobby or in your public space.
So they're just a visitor.
Mm-hmm. Mm-hmm. Now, will they try to intimidate your receptionist or your other individuals and flashing their badge to explain why they should be there? You know, yeah. So that's part of it is providing training, right? So individuals aren't intimidated. The same goes with police. And then it's also a balance where you want to be respectful of federal agents. You may need their cooperation at some point, just like the police, but you also need to protect your own facility and patients and visitors.
And we'll end the webinar with stuff we kind of covered in July. Those people who listened in July, that will be a rehash. But the idea of how you politely say no to people who show up. And remembering that principle of generally the louder someone yells at you, the less authority they have to be there, generally speaking.
And so what rights do medical facilities have? Well, so you don't have an affirmative legal obligation to report undocumented immigrants if they don't have a warrant or a subpoena. And I know a lot of big conversation out there is, should you even solicit this information? I think the only state that I'm aware of that may require it is Arizona. But otherwise, if you don't need to know, don't ask, right? That's just giving you more information that may put your client or your patient at risk. Obviously, HIPAA laws are still applicable to all your patients. And then can you refuse to give information? You can. Unless they have a subpoena or a court order, you don't have to give them information. And that you could let people know if they're in the lobby being questioned, they have the right to be silent.
And I think this is a thing that comes up a lot, especially in a highly politically charged situation. You're going to have employees who feel that they should report. And this comes up, I mean, it really comes up in a variety of situations. It can come up with drugs, it can come up with immigration, and there's often there's going to be someone who wants to call the cops on a patient. And I think one of the messages that employees have to understand is that there is generally going to be an ethical prohibition on calling the cops on a patient with limited exceptions, and those exceptions are primarily the patient is a threat to someone. And some people will immediately say, well, illegal immigration is a threat, but that's a little bit more esoteric.
Okay. So let's talk about ICE and if they do have a warrant, because that does change the circumstances. So first of all, we want to kind of give you a little bit of training about how to review a warrant, right? There are some very few basics. You need to make sure it's valid. Has it been signed by the judge or magistrate judge? What's the address listed on the warrant? You may be surprised. I get confused sometimes going to a hospital. I'm at the wrong location. They may be at the wrong location too, right? So you actually want to check, do they have the correct premise, or else you can kick them out, right? You do want to verify what's accurate. What's the correct time period? ICE is sloppy. Of all the agency, I will tell you, they're fairly sloppy. And so you want to check what's the time period and what's the scope, right? Is it a warrant that's going to allow them full access to your facility? Is it a warrant to get one particular individual? Is it a warrant instead for I-9s or document review? Once you've determined the warrant is proper, you've contacted your legal counsel, you do need to get out of the way. You do need to allow them to go ahead and effectuate the warrant.
Let me ask you a question. I have no idea what the answer to this is at all. You know, in the False Claims Act world, in addition to search warrants, there are a variety of other things that come up. You can get just a straight-up subpoena, civil investigative demands. There are a bunch of things that can confuse people because you don't know what they are. In that world, I always tell people the word search warrant is key. Are there other things that aren't a search warrant that ICE can show up with?
So they may show up with just a removal order. And the ACLU has some nice guidance, because what they often see is it's not signed, right? These agents were going to have them, they know who they're looking for, but they didn't go through the steps to go ahead and get it signed and executed ahead of time. And so those aren't valid warrants. What you'll also can see is they're just coming because they want document records, and those are going to be sent by subpoena, and most likely they're just going to be faxed to your organization. Rare that they're going to be served in people, and often they're just looking for particular information for an individual. Okay. So if they come in without a warrant, as we've discussed, obviously you can refuse their search. If they allege that they have probable cause that unlawful activity occurred, then you likely do need to note this But you can also still say, well, I don't accept that, but they're going to be able to go ahead and they'll have to prove it out later in court if there's an issue, if they allege probable cause to come in, basically crossing that line into that exigent circumstance that they're in the middle of investigation or they have a national security reason to be there. We talked about them waiting outside the hospital or clinic to see patients. That is an issue. And then arresting family members or other individuals coming into hospitals. That's definitely something you would want to report if that starts happening, because we just can't have that occur. So what do we recommend? Designate your public and private spaces, make it clear, because that will designate where ICE or other federal agents can be versus your own employees and staff. Be cautious of your files and other information that's visible to the public. Don't ask the immigration status unless required, and avoid listing that in medical or even billing records, because those are things that could be easily subpoenaed or reviewed that would bring them to their attention.
And a lot of these things are things, it's kind of common sense in the healthcare industry, right? And it's kind of a twofer for HIPAA reasons, and having files visible is a problem. The public-private space thing, all of that, there's a lot of overlap here, but it's a really good reminder.
And so who else could visit besides the ICE agents that I've talked about? And all those visits I've really been referencing earlier are the agency, the ERO agent, right? But you could have visits from the other departments of ICE. So we talked about HSI. Again, they have a broad range of activities. We're going to be looking at alien smuggling, human trafficking, document fraud, worker exploitation. We truly hope none of this is going on at your company.
So like ET, alien smuggling? Is that what we're talking about here?
I know, I hate that term myself, but that's how it's defined. These are what you'll hear about. These would be ongoing and long-term investigations, and if they come in, it means they likely know there's been a pattern of practice going on within your organization. But they also are going to do what I call more simple enforcement actions. So in this type of circumstance, they could be coming for one of your employees. So say, for example, you had a nurse working at your facility, and it turns out they had a prior deportation order, and they were using false documents to work for you, right? That's something that could happen. They can come with a warrant to arrest that employee. And that, in fact, happens very frequently. I get calls from employers to say, oh, my gosh, so-and-so just got arrested. What can we do to help them? Sadly, if that does happen, if they have an effective warrant, they are able to take that employee away. What we recommend is to have, contact, if you can, their family members, find out where they're being taken to be processed, so then they can help facilitate a lawyer to help out your employee.
And I think this is a good place that highlights the dilemma, because like human trafficking, this is a place where you can have the conflicting duties of sorts, right? If you've got a patient who's being human trafficked, you may have a legal duty to help protect that patient, right? They might be potentially a vulnerable adult or some other protected class, depending on how your state does it. And so you may have a legal duty of your own to help. That's where this balancing comes in. And I think to your earlier point, Deborah, sometimes you're going to be involving the police in situations. It's a fine line. Actually, and we do have a couple of questions. I'll interject questions periodically here, and people should always feel free to ask them. So one of our, Robert has suggested our owl-eared listeners, bat-eared, wants to ask, can ICE agents interview the staff?
So that's a great question, and it does depend on the nature of their visit. So ICE agents, if they're just serving an I-9 subpoena, they can't come talk to your staff. If they are conducting an investigation, likely they will ask, can I speak with your staff members? At that time, you need to stop and check with your counsel to determine, are they management, are they regular workers? You're going to want to control that circumstance. Normally we would say not at this time. If it's an FDNS site investigator, so you sponsored, say, a doctor for an H-1B visa, and they're there to check that they are following through in the material, most likely you're going to consent because you want to show, indeed, this is the doctor and this is the activities they're conducting, and here's payroll to confirm we're paying them the wages as we promised. You likely want to conclude that investigation as quickly as possible. If you don't respond or cooperate, what we see happen is they can revoke visas because they say you failed to answer questions, they weren't able to verify the information. So there is going to be a balancing factor depending on the reason that they're there.
So now if we're thinking like in the FBI context, if the FBI shows up at a clinic and they say we want to talk to your employees, the clinic, you get into this weird thing, you can't prevent your employees from talking to the FBI. But you don't have to really let it happen kind of during work hours. But you can't tell your employees you are forbidden from talking to the FBI because that's viewed as an obstruction of justice sort of situation. Is ICE any different in this context? Can you tell your employees do not talk to ICE? No.
But there's certain things, like if ICE comes in during a raid and says U.S. citizens to the right, foreign nationals to the left, you may say, look, we're not going to divide our employees in this manner. We will put all our employees in this XYZ room. There's certain things, but you as an employer, you're going to have to step away from advising your employees.
And Deborah's point, this is one where you pick up the phone and call Deborah, right? Because these hopefully are rare, and wrong decisions can have repercussions.
Indeed. So other agencies we talked about, the Fraud Investigation Unit. I do see this to be a large uptick, especially for foreign students. I know there's working with many universities and clinics, there's a huge group of H-1Bs and STEM OPT because of the need for highly skilled workers. And these site visits have just started, really for STEM OPT students. It had been in the regs but hadn't really been effective. They've been fairly straightforward, but there's certain things you're going to need to think of. You may not know who did their training program, who signed off on their training plan. There may only be one HR who even knows what's going on with that person, and no one even knows they're on a STEM OPT. So it's going to be important to have a central place where these are located. Likely those are going to be in their employee file, but you're going to want to make sure you know where they're at. So if they're asking questions about a training plan, you don't look blankly and say, we're not providing training, he works for us, which is true, but part of that work involves training. That's just the essential nature of their work for you. So those are things to be aware of. And then make sure your counsel, when you're sponsoring, they've always advised the employees. We always tell them, look, there is a risk you're going to be questioned by immigration. It's not because you did anything wrong. It's just because they want to verify that you're really the H-1B worker and that you're doing the job. So it's just important to be aware of that. And then we always recommend, please call your counsel right away to let them know what questions were asked, if documents were sent, what you sent. There's nothing worse than finding out after the fact when, oh yeah, we gave, maybe giving much more than was ever needed, because they can dig and look for more information. So be thoughtful. We've also seen an uptick in Department of Labor investigations, both on wage and hour division and LCA investigations. And for those of you who may not sponsor individuals, LCAs are part of H-1B. They make an attestation that the foreign national is being treated the same as U.S. workers and vice versa, and they're in the same wage scale, right, that you're not underpaying or overpaying a foreign national for the position. Generally, Department of Labor are triggered by complaints. So if they come to your workforce and are doing an investigation, very likely it was an employee complaint. They felt they were underpaid or misclassified, and they've complained to the Department of Labor, and now the Department of Labor is interested in your hiring practices and your payroll practices.
And I know what since I don't know what an LCA investigation is, if I got one of these, I'd call you. Is that the right thing to do?
That is
then?
the right thing to do, because they're again, just like ICE, they're also funded, and Department of Labor kind of gets excited about these because they have usually very little impetus on immigration, but from this perspective, they feel very strongly in questioning the prevailing wage that was used by employers. As you can imagine, they always aim high and always feel companies are underpaying. So what to do? How do you pre-plan? Well, we recommend, it's a long-winded word, but a worksite enforcement action plan. Essentially is be thoughtful about, okay, if this happens, what should we do? Well, you likely should designate a company representative. You know, who do you want this federal government agent to talk to at your organization? Make sure the receptionist or the individual is going to have the first contact, knows who to contact within the company, and has your legal counsel's information. Have an internal communication plan. Know who's the team that's going to be responsible for dealing with this so you can control the communication for the rest of your organization. Nothing is worse than someone immediately getting on your internal channel to say, oh my God, ICE is here, and every foreign national you may have work for you, legal or otherwise, is petrified, right? Nobody knows what's there. So you want to control the flow of information. And then let the individuals know, especially I call them frontline, but your receptionist, the nice friendly person who's going to be welcoming people to your organization, to know what to do if the police or if ICE do make an appearance, so they know who to contact. Okay, let's talk about some sample scenarios just to let you know what if something should happen. So in this case, ICE is just asking for your employee information. So what happens if ICE contacts you and says, I would like to have the employment records for Joe Smith, okay? What they're going to ask for, generally it's going to come by letter or by fax. They are pretty good now in serving it with a subpoena or a warrant. In the past, they had a generic letter that they'd send, but most of them are subpoenaed. And in many cases, these are coming because maybe that individual has applied for an immigration benefit, and likely either the immigration agent or OPLA, the prosecutor, and their removal proceedings doesn't maybe believe them. In many cases, we see this because they want to check someone's employment history, and they disclose they work for your organization from 2005 to 2010, and they want to see what did they fill out in their employment questionnaire and what's in their I-9. Often they're looking to see if they made any false claims to be a U.S. citizen, if they presented false documents, or if they've then given any false information to immigration. If they have served a proper subpoena, you are obligated to comply with that request. If they ask for things beyond the employee records, obviously if they're asking for anything that would be covered under other data privacy acts or rules, you need to keep those into consideration or make sure the subpoena covers or overrides those laws. If ICE asks if so-and-so works for you, that is an answerable question. That a subpoena or a warrant is not required to get that information. 100%, the subpoena or ICE will on it, they'll say, and don't let the employee know. Of course you can tell the employee. That's not a secret. There's no law that prevents you from telling the individual, oh, by the way, ICE had requested your information. And in fact, it likely is going to require you to call your counsel because you've just been put on notice that there may be something in this employee's background. And likely we would advise you, let's take a look at the I-9 and information and just be on the lookout because there could be a future consequence that could happen. Obviously, don't take action yet, but those would be things that you want to start considering.
And just reinforcing Deborah's point, and we'll talk about this a little bit at the end, but you can always, with the exception of terrorism investigations and banking investigations, you can always tell someone about a government investigation. So,
thanks for this. Okay, let's go with a scenario number 2. ICE execute an administrative removal order. So this is when they're targeting to arrest, this time we're also saying one of your employees. So this can happen. So again, just as we walked through, they need to have a subpoena or warrant. So take a look at it. We, if possible, have them say, of course, why don't you sit here? Let me get you a coffee. I'm going to call them. So you need to get the employee, so let the employee know that ICE is here and they're going to need to meet with them. And then again, get the employee's family or contact information if the employee is then arrested. Just like the obstruction of justice, you cannot impede ICE if they have a warrant for an employee's removal. But you're welcome to ask questions regarding, is there something we can do? Where are they going? Can I call his family? Some of these agents are willing to let you act on their behalf, and some of them will shut you off, but it doesn't hurt to find out.
So in that vein, there's a situation in Massachusetts where a judge is in trouble because she told a person in her court, hey, ICE is out front, go out the back door. If ICE shows up, can a clinic tell people flee, right? Can you affirmatively tell people they're here, you should sneak out the back door?
I would like to say yes, but likely no. Yeah, again, that's going to be obstructing a police operation activity. And that's when, I think a person can choose to do that, but you have to do it knowing that, like the judge, you may wind up facing consequences. You may face those consequences head held high, but there may be consequences. Indeed. Then you start coughing, ice, yeah, and see what happens. But no, good point. That is my favorite behind the music. I promise no 80s, but the Vanilla Ice behind the music is one of my favorite, as he explained that he had not stolen the riff from David Bowie and Queen, but we digress. Love it. So I just want to mention, this is not really concerning ICE, but I thought it's an interesting impact on, I think, healthcare communities is what's called the public charge rule. And so there is a law in immigration where if someone is planning to become a green card holder, they have to show that they would not become essentially public charges on the government, right? They're not going to be a burden on our nation. And that's been on the books for forever. But on August 19th of this year, they issued a revision to the public charge rule that specifically states that accessing Medicaid is a ground to make someone inadmissible and prevent them from getting a green card. And what happened when this was first released is their proposed rule was extremely broad. It impacted U.S. citizens' family members of the beneficiary of these benefits. It impacted children. It impacted our service members using Medicaid or benefits, essentially targeting all poor people who want to get green cards. It was a pretty broadly written rule. Fortunately, when the final rule came out, it had been narrowed in scope, and it did create some more humanitarian exceptions in making this finding. So it does have exemptions. So those serving in the armed forces are exempt. Individuals who are here because of asylum or refugee status are still allowed to access benefits. And individuals getting green cards under the Violence Against Women Act, so battered women or men and abused children can still qualify. They've also allowed children under age 21 and pregnant women to still get benefits without being used against them. Everyone else, however, if they use Medicaid except for an emergency, they are going to be barred from getting a green card. And that created a huge element of fear in immigrant communities. I mean, before this final rule came out, everyone was calling, oh my gosh, what if happened and my child was sick and we took benefits and we needed to get care, and people were scared to qualify to receive benefits that they qualified for this risk that they would never be able to bring over family members. And this proposed rule even applied to individuals who wanted to become citizens. So it was basically a way of preventing poor people from gaining immigration benefits in the U.S. So the new law goes into effect in October. It is much narrower in scope, but the messaging has not all gotten out to the public. So I do believe that healthcare communities are going to see people not accessing care that they otherwise qualify for and not having the means to pay for it unless they go through emergency care. And I think this just could have repercussions because of the messaging. Does the act of applying for Medicaid
if you're a green card holder, prevent the application for citizenship under what's taking effect in October?
Not the new law, but it could prevent them from petitioning to sponsor another immigrant to come to America. So, for example, they can't bring their spouse over now because they've accepted benefits. So essentially, it's a punishment for being poor in accessing care. Because they say, well, there's a risk that the person you're sponsoring could then need care because you haven't shown that you're independent enough.
So it doesn't affect the individual, it affects
their future.
Their ability to bring others over.
Exactly. Or if you have, it could affect individuals in non-immigrant status. So say F1 students, for example, if they wanted to change status, they could be barred from doing so. Mm-hmm. So it's relevant because we have seen just a lot of misinformation, and the original rule was so bad, it just caused fear just across people of taking benefits, and I thought it was worth referencing.
So I think we may have set a record for the number of questions here. And so the way this is going to play out is I'm going to ask the questions now, because after that we're going to go through the sort of what you need to know, sort of general tips for communication from government agents that we'll rehash what was covered in July. So if you heard the July thing, you'll be able to skip that if you want. But we got a bunch of really good questions here. So one, I'm going to start with one that kind of fits with that. So how does this relate to trying to get Medicaid coverage for undocumented immigrants for emergency treatment? You kind of have to ask the patient about their immigration status if you're going to help them get coverage. So how does this all jibe? Well,
it doesn't prevent them from getting the care. It just impacts them in the future if they want to get benefits. So what I'm saying is they can still qualify to get Medicaid, but they may not want to get it because they're fearful it will prevent them from getting a green card.
And that's a really interesting pickle for if you've provided high-cost care to a patient. Mm-hmm. And I don't know the answer to the question of whether you can force someone to apply for Medicaid. I would think the answer is a resounding no, but I guess I'll have to ask my colleagues this one because I don't know. I don't think you can. What's the time frame for verifying a warrant? Can you wait until you hear from legal counsel?
Likely depends, I would say. Certain things like an I-9 warrant or a document request subpoena is going to have a time frame. Usually you have a 3-day window on most circumstances, and if you need more time, you can call and usually communicate to say, if it's a warrant executed because they're immediately going to take your computers and your personnel, you have very little time.
And basically the way warrants work, functionally, you can try to object to the person, but you don't prevent them from executing them. You let the person execute the warrant, and then you object afterwards, is sort of Warrant 101. So if private spaces aren't clearly designated and labeled, but they are in fact private, how do you recommend on pushing back on ICE access? And
I think you would need to then verbally tell them this is a private area. Hopefully that area has some signage or has a lock, something to say, but I think you need to make that verbally known, that you advise them that this is a private area and you're going to restrict access.
And I think as every parent has said, you use your words.
Exactly.
Okay, what are the, we'll talk more about that in our next chunk here. What are the repercussions for employees who used soft documents?
Not sure.
And I actually wondered if I had not been paying attention when the term soft stop, because I do not remember you using that term, and it wasn't one I knew. So we'll move along.
Feel free to write in a clarification, and we can answer.
So here's one I don't expect you to know the answer to, and I don't know the answer to it. I've got colleagues. Well, first I'll tell you what the question is. So if your facility is a weapons-free facility, can you request that the ICE agents not enter the public area with their weapons? Now, I got a couple of colleagues, Pari Magera, Katie Ilton, and Briar Andreessen have been working a lot on sort of facility issues, and so I would turn to them for answers on things like this. I will tell you my off-the-cuff is I would not ask a government agent to surrender their weapon. I just wouldn't. But that's my answer as a David Glazer person, not as a informed. I also think you probably can ask. You can always ask anything, but I don't think you could require it, and I don't think I'd ask personally, but I've got 3 smarter colleagues than I. So here's another one that I don't know that I know the answer to. So what, besides HIPAA liability, are the legal risks if staff let ICE into private areas when ICE doesn't have a warrant? And HIPAA liability, I mean, I guess to me, the answer is confidentiality generally. It's sort of the general duty to the patient. And so I think a patient could assert that you had breached the duty. There might be more. I would turn to my owl-eared colleagues. I think you answered this one, but there's a question, are they looking for staff or patients?
That could be both. Mm-hmm.
So, okay, I got a couple more here. We have had patients that we suspected to be illegal immigrants present to the hospital using another person's ID and insurance card. What are your suggestions for dealing with these patients? We obviously do not bill to an insurance company if we know that's not their true identity. We treat for emergencies. Would you recommend calling police in this situation? So here's my thing. I think it is, you can't, I think the person put it well, you can't bill using fraudulent information. You don't generally have a duty to report crimes. You do have a duty to avoid participating in crimes. And so you can't submit a claim if you know the thing is, that the thing is wrong. I am not a fan. I basically personally think you don't call police on patients. It's with the exception of, I have the one exception, which is if the patient is a threat to others or themselves. That's my one exception. And actually, even themselves, I'm a little bit worried because police and mental health issues are not always perfect. But if they're a threat to others, I call the cops. Otherwise, I think there is often an ethical question there. And if they are if someone's in fact committing fraud, the odds you run into trouble are very small. If they're not, another ballgame. And so my error there would be the potential penalty of calling is there's a real potential penalty. There's basically no penalty to not. My advice generally is not. Is there a simple message that we as healthcare providers can or should put out so individuals do not disenroll in Medicaid? So this is kind of to your last question. Mm-hmm. What do you say to people to calm their fears?
Yeah, that's a great question. I do know, in doing some review, many of states are actually putting out guidance to clinics and their healthcare facilities about this public charge rule and how to deal with it and how to address this issue. I mean, you really can't give advice regarding immigration, but you can tell them this is a very significant bill and Medicaid will help you in this manner, and just provide it from your own perspective of the benefits from the services that you're providing, and leave kind of immigration out, and say if you have questions as to how this may impact you, you should probably go see and have a list of nonprofit immigration service providers that could be referred out.
In just a moment here, I will take over for a second, but do you in fact, do you have a trivia question, I think, right?
Oh, sure. I can do a trivia question. So, okay, this is really odd to talk about a serious subject and do trivia, but sure. Since we're doing immigration, David had asked me to come up with the civics questions that are currently being asked of individuals applying for naturalization. And so I thought I'd add to our trivia question here and just pick some to say, so you guys can all see what it's like.
Yeah, let's do two. Okay. We'll two, and the answers to these first two questions win a prize.
Okay. How many original states were there, and name 3?
Okay, so we'll let people process that one for a second. So how many original states? I think that one I could answer for sure. I think I could come up with 3.
Not bad. Under our Constitution, some powers belong to the federal government. Name one power of the federal government.
Okay, so our second one is a federal government power. And so the first person who got, you don't have to get both of them right. There will be 2 prizes for each of those. All right, so if you have heard this part before, there's nothing terribly new here. It'll go really quickly, but there could be a refresher in here. These are just tips for what you need to know if you're contacted by a government agent. So first, government agents generally do not call. They sometimes call, but they generally do not call. Be extra suspicious of someone calling you and asserting they're from the government. I know I've gotten that IRS phone call telling me that I have failed to pay the IRS. And they spoof the number. It looks like it's coming from the IRS, so it's rare.
And I will note, though, if you're a foreign national, from certain countries. It's very common for HSI or the FBI to call you.
So that's something I did not read. So that's a, and so if you have any doubt, the thing is, call them back, right? Just say, oh, hey, what's your name? What agency you're with? And then don't call back the number they gave you. Look, call the agency's switchboard and say, I need to speak with agent so-and-so. And if you're polite, Deborah made this point, just being polite is always the way to go when you're interacting with the government. If it's okay to dispute something they're doing, just don't be jerky about it, be friendly. And sometimes people will get all in your face, but usually they won't. And if you say, hey, I just want to verify this, I'm sorry to bother you, but could you just give me your name and I'll call you back through the switchboard? Any real agent will not be troubled by that. They will understand, and that won't freak them out. If someone gets mad at that, they're probably not a real agent. Okay. Also, it's like a reporter. Like, generally, you want to take the time to think. Like, I never talk to a reporter when they call in. I guess there's a Nina Youngstrom exception to that if she's listening to this. When she calls me, I will sometimes talk right off the show. But otherwise, I want to gather my thoughts and call back. So if armed agents show up at the door, if they've got a warrant, you have to let them in. And we talked about this, but how do you know it's a warrant? It will have the words search warrant on it. And anything else that's there, if it's CID, subpoena, grand jury subpoena, subpoena ducis tecum, all these other words, it's not a warrant. It says in the bold middle center search warrant, if it is. You don't have to talk to agents. We recommend strongly that you don't. Get their business card, because they have one, and call a lawyer. They will tell you it's not a big deal. That is like Officer 101. Oh, this isn't a big deal. The fact that they're there proves that it is, because they don't waste tax dollars. They don't spend their time on things that they don't think are big deals. They go get a cup of coffee if they had nothing else to do. Agents love to get you talking, and that's often done by making you either feel comfortable or scaring the socks off of you. Keep your socks on, but don't talk. Just be quiet. If you say, oh, are you here because of the X, that waives the attorney-client privilege, so you don't want to do that. People feel like they are admitting guilt by not talking to the police. That is not true. And police officers, if you watch any cop shows, you know they are frustrated when people get their legal counsel involved. They may think you may be right that they get suspicious, but they can't do anything about it, and it frustrates them. And they really, really, really want you to talk without getting legal involved, because when legal is involved, the odds of you getting into trouble go down. And most officers have some incentive to get as many people in trouble as they can. And so, and that sounded too cynical, and I don't mean to sound that cynical or harsh. I think most officers only want to get people who really did something in trouble, and they do think us lawyers will help keep the guilty free. But as a corollary, we also help keep the innocent free. The agent can't make anyone attend an interview. Put an asterisk there if you are a licensed professional, and remember that licensing boards can often require an interview, but other folks can't. Although ICE can require immigrants to talk, I assume, on some questions? Or can ICE make anyone?
No, you can. If ICE is questioning a foreign national, they have the right to remain silent. Okay. They will likely still be arrested, because then they can't prove if they're a U.S. citizen and not a foreign national. So eventually they will talk once they're sitting in a jail cell, but they are not obligated to give them their time and manner, place of entry. But caveat, never ever lie, though, to an officer. And that one is
super important. The shorthand, and people who follow government investigations, you hear Section 1001, that is lying to a government official, sends you to jail. And in fact, if you've done nothing else and the only thing you do is lie to the government official, that can still send you to jail. They can't get documents without a warrant or a subpoena, and basically, if someone does a subpoena, you can talk to counsel. There you've got time. Warrant, you got to get out of the way. Everything else, it's better not to give it, because once you give it up, you can't get it back. So warrant, you kind of have to err in getting out of the way. Everything else in the world, you've got time to talk to counsel. And I've talked about this before. Medicare has immediate access to medical records. That act is defined as 24 hours. You always have time to check with counsel if they don't have a warrant. They can't get privileged information, and Deborah made this point. They can't tell you not to talk about it. They can ask, they can request, they can beg, they can't command that you don't talk about it with anyone else. You can't prevent your employees from talking to the government. If they talk, as Deborah just said, you'll go to jail, and don't destroy and hide documents. I'm skipping ahead for a second because we have our little sticky thing with the QCR code. If you have the crazy desire to connect with either Deborah or I on LinkedIn, you can, if you just hold your LinkedIn app up to the screen here, it's kind of weird and a little creepy, I would say a little creepy, but you will instantly be able to connect with us. Basically, just in the search bar, there's a little thing that looks like a Foursquare board. If you push that, it'll scan what you see here, and you will be connected to us. Did we get more? Actually, I'm going to see here if Robert has more questions from us. I don't know that I see that, so I will end by noting our upcoming webinars and their dates, which are October 16th. It's a week late. Our frequently asked questions. I do see that someone already sent one during this very webinar. So thank you to EG, you know who you are, for sending me a FAQ. You can send those in. You can send one to me or to Katie Ilton, and we will try to include all of those. On November 20th, Ryan Johnson and Katie Ilton will be talking about telemedicine. And then on December 11th, our whole gang will be talking about hopefully what will then be out, the physician fee schedule rule for 2020, the inpatient and outpatient prospective payment rules and the like. So it's our annual regulatory session. So thank you so much for joining us. And if you do have additional questions, you always can call Deborah at the number and or email her as in there, or her other colleagues in the immigration group. Thank you so much for listening.
Thank you.